I am honored to be on the program here today with Whitney and Ben Friends, who were part of the doers of Nuremberg, the Brigade of Doers. And I remember meeting Whitney Harris in the courthouse, Commander House, is that right? And of course, Ben and I were very close. There's one secret on my relationship with Ben that I have to tell you. And that's, we see it eye to eye on the big issues, Ben. That's you and I together. But there's one little issue that's very divisive. And that's who's the youngest prosecutor at Nuremberg. I wanted to make myself distinguished, so I said I was the most important, the youngest prosecutor there. And I thought I had it. I was very comfortable. And in one conversation with Gertrude, but wife laughing all the way, he raised the question, he might be the youngest prosecutor. Do you know what he did? He went to Transylvania, got his birth certificate, which is in Romania. I can't understand the certificate. And I'm moving to close the gap. I'm inching over to your position, and maybe by another decade, I'll be there. Oh boy, well, without Nuremberg, what? First, a word of background. The Nuremberg trials established modern laws of war and laid the foundation for the ad hoc international tribunals erected in the past 15 years and the permanent International Criminal Court. But one of the difficulties in comparing Nuremberg to its modern descendants is that the Nuremberg trials were conducted under ideal conditions. Germany and Italy had unconditionally surrendered, and the defendants were already in the custody of and under the control of the victorious power, as was an enormous amount of incriminating documentary evidence. The world's nation-states as a whole endorsed the trials, and the daily press coverage made its proceedings transparent and understandable by the general public, including the Germans. Modern war crimes tribunals have not been conducted with the same ideal circumstances, under the same ideal circumstances. Major powers on the UN Security Council have not given their unstinted support, particularly where they deem their self-interests are at stake. Financial shortfalls have been hampered the gathering of evidence and the apprehension of indicted defendants, both tasks which have been made even more difficult by uncooperative local governments. And sparse media coverage, with the exception of the superstar defendants like Milosevic and Hussein, has resulted in apathy, misunderstandings, opposition, and proceedings wholly unknown to the victim. Still, these courts have implemented the Nuremberg principles, even expanded on the crimes over which they have jurisdiction to now include rape and sexual violence and the forced use of children as soldiers. In spite of the imperfections, they are carrying on the legacy of Nuremberg. Nuremberg was designed to replace the law of force with the force of law. This was indeed a revolutionary concept. Since civilization began some 7,000 years ago, the law of force had been the order of the day. We should never forget that the law of force is barbaric, fleeting, and creates tremendous uncertainty on the part of the populace. That means that highly cultured, peace-loving people could be and have been destroyed by foreign and domestic predators who recognize no limits to their behavior. Albert Speer, prime defendant at Nuremberg, recognized the dilemma created by acceptance of the law of force. In his closing statement at Nuremberg, he graphically expressed his concern over a future in which some nations devoted their efforts to producing greater weapons of destruction, while others focused on cultural growth and peace-loving pursuits. He hoped that Nuremberg would ensure that the growth of international law kept pace with increases in the technology of destruction. In today's world, many nations accept the rule of law as the order of the day. This is particularly true of the European nations, who are members of the European Union, who accept the rule of law in economic matters. Around the world, 102 countries have ratified the Rome Statute, creating the International Criminal Court. Hopefully, the list of states who accept the rule of law will grow significantly as nation-states recognize that it is in their best interest to do so. We need to recognize the benefits of the rule of law in certain areas. For example, international human rights cannot exist in vacuum. To be effective, they must be supported by a rule of law. Human rights are respected in Europe because of the European Human Rights Convention and the court to enforce it. The principles underlying this convention were spawned at Nuremberg. Today, much of the world condemns genocide and ratified the 1947 Genocide Convention. There are, moreover, several tribunals in operation today whose function it is to punish genocide when it occurs. This is because of a rule of law directly emanating from Nuremberg. It condemns genocide. Genocide is barbaric, it is inhumane. Yet before Nuremberg, there is no international law to punish those criminally responsible for it. Individuals at several points in the globe are being tried today for genocide. This is one of the graphic illustrations of the long reach of the Nuremberg precedents. Before Nuremberg, there was condemnation of war crimes through the Hague Conventions of 1899 and 1907 and the Geneva Convention of 1928. But no structure had been established to try individuals accused of war crimes. Nuremberg gave black teeth to the principles agreed upon governing the treatment of civilians and prisoners of war. Until Nuremberg, these principles, although agreed upon by many nations, were not enforced. Then the Nuremberg Court enforced them, so that today they're an integral part of international law as recognized by the tribunals currently trying individuals for war crimes. These crimes are precisely defined by the laws governing the operation of these tribunals. Trials for these crimes are not a matter of whim. They are required by the rule of law and common moral decency. While these trials should be the order of the day, they still often take second place to politics and economic calculation. Security Council was remarkably slow to act in the crisis in Darfur because of little domestic political will for intervention, and the close economic ties between Sudan and several permanent members of the Council. Amnesties and immunities are still used as a way of ending wars or conflict. Without compunction under a rule of law, these individual defendants could well escape trial, depending upon the political circumstances involved. History has repeatedly shown that this is to be the case. The rule of law should be all-encompassing. The rules need to be enforced by international tribunals with no exceptions, as was the case at Nuremberg. This was indeed what made Nuremberg so historically important, because this approach had never been followed before. That's why Nuremberg remains inspirational today, in spite of gaps in prosecuting crimes against humanity. Without Nuremberg, there would be no real hope of trying those most responsible for these crimes. The area of international law where Nuremberg's inheritance is more cloudy is aggressive war. The problem here is the Nuremberg Tribunal's judgment was not generic in this area, but dealt with a particular factual situation at hand. The tribunal found that what the Nazis did constituted aggression, but its language in the judgment did not clearly cover all parallel or related situations. This was the vital count not fully dealt with at Nuremberg. An ad hoc approach was not enough. The United Nations Charter attempted to fill this gap by prohibiting the use of force except where authorized by the Security Council or in self-defense if an armed attack occurs. However, there is no international legal system established to deal with violation. The only recourse built in the Charter for dealing with the acts of aggressive war was through the Security Council, which has often been constrained by international political considerations. The problem this gap has created was that it allowed nations leeway in defining for themselves what did or did not constitute aggression. The result has been that some nations, including the United States, have been able to self-define in their own interest what does or does not constitute aggression. As a consequence, the tragedy is that as yet there is no clear-cut, mutually acceptable rule of law applicable in this critical area today. One only need to look at North Korea's invasion of South Korea, the United States and Panama and Grenada, USSR's invasion of Hungary and Czechoslovakia to see that there is indeed a glaring gap in our inheritance from Nuremberg that must be corrected if peace and security are to be the order of the day in the world of the future. To understand what the world would have been like without Nuremberg, let's take a look at the following probabilities. First, there would be no enforceable international human rights because they had not been articulated in any court with enforcement powers. Without Nuremberg, an enforceable international human rights legal system would have to be developed from scratch. But what act would be so horrific for the world to demand or accept such a system if the Nazis' atrocities did not result in such? The end of World War II was a now or never opportunity to face the issue of genocide and crimes against humanity. Nuremberg marked, indeed, the birth of the concept that all individuals have certain inalienable human rights which transcended the boundaries of nation states. This was a great step forward in human development. There might not have been a genocide convention without Nuremberg. After all, the Nuremberg indictment first identified genocide as a crime in the judicial proceedings. Moreover, genocide was condemned by name in the closing remarks of the British and French prosecutors. Nuremberg gave genocide visibility, and the evidence produced at Nuremberg drew the world's attention and sympathy. World War II was fought largely unaware of the atrocities being committed. Nuremberg was not just a forum for examining and condemning genocide. It was the world's first conscious attack on genocide. The fair statement that genocide would be far more prevalent in today's world without Nuremberg. The war crimes area of Nuremberg punished those surviving top Nazi leaders whose policies and actions were responsible for commission war crimes against civilians and prisoners of war. The result has been that the military field networks of the major nations today incorporate the Nuremberg principles in the war crimes area. Nuremberg has revealed gaps in the then current laws, also revealed gaps in the then current law in the area of war crimes. And the nations of the world subsequently attempted to bridge these gaps through the 1949 Convention, and to a large extent this has been accomplished. Unfortunately, however, this legacy has been tarnished. The United States, which was the driving force behind Nuremberg and the creation of clear standards for the treatment of civilians and prisoners of war. The Nuremberg principles have been firmly enshrined in our military field manuals and in the Uniform Code of Military Justice. However, by violating the Geneva Convention and the treatment of captured combatants, through torture and indefinite detention without trial, the United States is committing the same crime as the rogue nations we're opposed to. As previously mentioned, the big gap in today's world world's inheritance from Nuremberg is in the aggressive war area. This is in part because of lack of definition as to what constitutes aggressive war. Although attempts have been made to define it by agreement on any agreement on any definition has not been possible. This has been primarily because some leading nations have been unwilling to give up sovereignty in this area. So there's much to be done in order to promote a secure future for all of us. As to the urgency of this, we need only harken back to the words of Robert Jackson, the U.S. Chief Prosecutor at Nuremberg, when he said that aggressive war was the primary crime dealt with in Nuremberg. I believe the tribunal also said that. Nuremberg took us a long way on the path of avoiding human destruction by giving us a blueprint for a rule of law. But there's still much ground to be covered in building a secure world for all of us, particularly in the aggressive war area. We need to make urgent efforts to meet this challenge, not only for ourselves, but for future generations. One question which clearly arises in light of the foregoing is what effect did all these limitations have on national sovereignty? Here we should note that national sovereignty was comparatively free from limitations from the date of the Treaty of Westphalia in 1648. And nation-states were free from the Pope's domination until 1945, the date of the start of the Nuremberg trials. Up until then, national sovereigns and leading members of their governments and military performing acts of state were under no legal restraints whatsoever. Thus, Nuremberg marked a revolution, stripping them of their absolute impunity and holding them individually accountable for their policies. Regarding the foregoing, some specifics about the changes brought about by Nuremberg are in order. First, Nuremberg denied the concept of sovereign immunity. In 1945, the leaders of Nazi Germany were put on trial at Nuremberg, and the Kaiser, who is credited with having much to do with the start of World War I, was, until his death in 1941, living peacefully at Dürr in the Netherlands. Subsequent to Nuremberg, denial of sovereign immunity has meant that Slobodan Milosevic, Augusto Pinochet, Saddam Hussein have all been denied immunity, have been subject to trial in courts of law. This was indeed a revolution. It meant that sovereigns and their high-ranking officials were to be held responsible for what they did in the name of nation-states, their nation-states. Second, Nuremberg denied the defense of superior orders. What this meant was that at Nuremberg, superior orders offered no excuse for criminal activity. Here, personal observation is appropriate. On the basis of what Albert Speer told me, I believe that the final solution, which involved the extermination of the Jewish race from Europe, was orally ordered by Adolf Hitler. Speer told me that no one else would have had the authority to make such a drafted move. Defense of the Nazis at Nuremberg, including Otto Hohenzollern, Commandant of Einsatzgruppe D, and Rudolf Host, Commandant of Auschwitz, was that they carried out Hitler's orders in the extermination of Jews. This defense was denied and there was none further action. The necessary implication of the denial of this defense is that a higher law of government, namely international law. Third, a close examination of crimes against humanity found at Nuremberg, as reflected in the London Charter of August 8, 1945, discloses that in conjunction with certain crimes against humanity, and particularly genocide, domestic law offered no excuse for defendants charged with committing these crimes. One gruesome example is the law for the prevention of hereditarily deceased offsprings, which led to the forced sterilization of women, and eventually the T4 euthanasia program, which was responsible for 200,000 deaths. Count 3 in the Nuremberg indictment included the sterilization of women at Auschwitz and at Ravensbrück. And the defendants were not able to justify such barbarism under sterilization law. To summarize, what this meant is that national law in such a situation was no longer controlling, and that by implication, a higher law, namely international law, governed. This was a severe limitation on sovereignty as it existed in the pre-Nuremberg era. Another encroachment on national sovereignty was Nuremberg's endorsement by implication of the concept of universal jurisdiction. Basically, the Nuremberg judgment states that the four allies conducting the prosecution at Nuremberg were doing collectively what each of them could have done individually. The Nuremberg judgment lays the groundwork for the concept that some crimes, particularly crimes against humanity, were so egregious that the accused could be tried anywhere without any jurisdictional connection between the trial court and the situs of the crime, because they were crimes against all humanity. The concept of universal jurisdiction was applied in the Eichmann case by the Israeli court. Here we need to keep in mind that when Adolf Eichmann committed this crime, Israel was not even in existence, and thus he could not have been subject to Israeli law. But the Israeli court, basing its opinion in part on Nuremberg, said that Eichmann's crimes were crimes against humanity, and therefore subsequent Israeli law could be applied at the trial. This was indeed an enormous step in holding individuals responsible for crimes of great magnitude. It also represented a limitation on sovereignty. Eichmann was, after all, a German national. He was seized in Argentina and kidnapped by Israeli agents. In effect, the case obliterated the lines of national jurisdiction and rejected traditional legal limits to the exercise of legal rights of nation states in the criminal area. In light of the foregoing, the necessary implication is that Nuremberg established certain fundamental international human rights that existed regardless of nation-state endorsement. This was indeed a severe limitation on sovereignty. Well, where are we now on the recognition of the Nuremberg principle? The developed world, particularly Europe, Canada, and Australia, much progress has been made. This is true of certain countries in the developing world as well. But in China and Russia, forward progress has been glacial, and in some cases they have played the role of ghosts in fighting against the rule of law in the world. Neither has, in fact, joined the International Criminal Court, which would institutionalize the Nuremberg principle. On the other hand, neither has vetoed the UN Security Council resolution for the creation of ad hoc war crimes tribunal covering the former Yugoslavia, Rwanda, and Sierra Leone. Nuremberg was an American invention, and Supreme Court Justice Robert Jackson, who created the vision of Nuremberg, stated, quote, "To pass these defendants a poisoned chalice is to put it to our lips as well." What he meant was that the United States and the other allies who sought justice at Nuremberg were going to have to abide by the Nuremberg principle in their own behavior in the years that followed. Today, both Great Britain and France are parties to the International Criminal Court, which is implementing the Nuremberg principle. The United States has not only refused to join the court, but has made extreme efforts to sabotage the operation of the court. More specifically, the United States cut off military aid to some 35 countries who refused to exempt U.S. soldiers from the court's jurisdiction in their countries. The problem basically is that the government of the United States does not want to submit itself to the same rules that apply to other countries, and has convinced the American people that this is the only way to keep them secure. Case in point is that of the UN International Criminal Tribunal for the former Yugoslavia. In that case, at the instigation of the U.S., the UN Security Council set up a war crimes tribunal charged with applying law based on the Nuremberg principle. Parallel tribunals were set up with U.S. endorsement under UN auspices in Rwanda and Sierra Leone. The U.S. was emphatic in support of these efforts, sending both personnel and money to implement them. These were instances where the Nuremberg principles were being applied to the actions of others. But when it came to applying the Nuremberg principles to its own action through the International Criminal Court, the U.S. said an emphatic no. Hopefully this hypocrisy will be revised with the advent of some future administration. Protecting our leaders from accountability is not the same as protecting our national interests. Tragically, the Nuremberg principle, which holds sovereigns responsible for what they do in the name of their citizens, has been a stumbling block for the development of international law. For example, my judgment, the U.S. government does not support the ICC, not because our servicemen might be tried, because so long as the U.S. is prepared to police its own, the ICC does not have jurisdiction, because our leaders could be. The Constitution, the values it embodied, protect Americans from the abuses of government, not abusive government from the people. Sovereignty lies with the citizens of a country, not their government. One final thought, and that deals with the crime of aggressive war. Jackson thought that this was a fundamental crime dealt with at Nuremberg. This is an area where not much progress has been made since Nuremberg. This is, however, a crime within the jurisdiction of the International Criminal Court, subject to being defined and with the definition being approved by 7/8 of the parties to the court. This cannot happen before 2009. Currently, efforts are underway to define aggression in anticipation of the window through which it will become part of the court's jurisdiction. History has witnessed U.S. aggression in Grenada, Panama, Vietnam, and Iraq. Many U.S. soldiers have been killed in the process, and these military actions have been extremely expensive to the U.S. Moreover, they have hurt our image in the world as a peace-loving nation and as an advocate of the rule of law. Speaking as a former U.S. prosecutor and a U.S. citizen, I believe it was best for the U.S. as a country to restrain its leaders by international agreement from committing aggression. The standpoint of national self-interest, we should take this step forward at this time. We cannot afford the cost of war indefinitely in terms of human lives or expense. As a step forward at this time, I would like to see the United States propose a non-aggression pact with those nations who would be willing to accede to sign. Such a pact would define the benchmark of international behavior in this area. Proposing such a move, I say emphatically that the weapons of destruction in the world in which we live are too powerful to be left unchecked by legal restraints. Many of the U.S. abuses and blunders have been in part due to uncertainty in the changes in the world. The Geneva Convention, the UN Charter, the spiritual brothers of Nuremberg were designed with states as the main actors. However, in today's world, non-state actors, such as terrorists and drug cartels, are in some cases, in some ways, a more potent threat. Certainly, they are more flexible in responding to state action. However, they're not adequately accounted for in modern international law. Criminal and international law's handling of terrorism is a perfect example. Are terrorists criminals or POWs? How do you effectively gather intelligence necessary to prevent an attack if it will not stand up in court as evidence under exclusionary rules? The United States has now the opportunity to take the lead in this aspect of international law. Identifying and addressing gaps in current laws and treaties could be the most significant legal development since Nuremberg. For the remarkable low price of making our leaders live up to American values and commit to international standards we helped create, the U.S. could lead the world in agreeing to new playing rules which could effectively counter genocide, terrorism, and the threat of rogue states. Addressing you here today, I spoke to you as an institutional member of Nuremberg, and as a citizen of the world, I believe profoundly that Robert Jackson's vision at Nuremberg is as timely today as it was then. We need to move forward with a deep sense of urgency in bringing Jackson's vision into reality in today's world, not only for ourselves, but for future generations. I am confident that we can do so if we will it into our future. Thank you.